thesis and overview.
This is our thesis statement. In 1970, Jane Roe sued Henry Wade, saying a woman's right to abortion was protected by her right to privacy. After taking it to the Supreme Court in 1973, the court ruled that banning abortion went against the U.S. Constitution. This landmark case made abortion legal throughout the U.S. and explored a new frontier of women's rights and reproductive rights. Jane Roe became pregnant with her third child in 1970 and sued the district attorney of Dallas County, Texas, Henry Wade, saying that her right to abortion was protected under her right to privacy, which fell under the 14th Amendment. With the help of attorneys Sarah Weddington and Linda Coffey, they took it to the Texas Supreme Court, where they voted in favor of her, the plaintiff. When Wade disagreed, Roe filed a grievance, and on December 13, 1971, they argued their case to the Supreme Court. Roe, Weddington, and Coffey re-argued their case on the 11th of October, 1972. The Supreme Court released their verdict on January 22, 1973. The Supreme Court did divide the pregnancy into 3 trimesters, with abortion being legal in the first trimester, in the second trimester is to save a life, and in the third trimester, abortion was almost impossible.
Background and buildup. Long before Roe v. Wade, in the early 1800s, abortion was legal across the country until the woman could feel the movements of the fetus. Abortion was extremely unsafe, highly dangerous, induced by dangerous drugs, with some methods proving to be fatal. By the 1850s, attempts to criminalize abortion rose. The Catholic Church banned abortion in 1869, and in the late 19th century, the U.S. passed several laws making abortion far more difficult. Among the laws, one of them was the Comstock Law, which forbade the distribution of abortion-inducing drugs by mail. By the 1880s, abortion was outlawed in the majority of America. Regardless, more than 200,000 to 1.2 million women continued attempting illegal abortions. This includes Jane Roe, who at the time was pregnant with her third child. At the time, she was unsuccessfully trying to get an illegal abortion. During the 1960s women's rights movement, some court cases laid the groundwork for Roe, and a few states had legalized abortion, including Alaska, Hawaii, New York, and Washington. In 1970, Roe and her attorneys filed a lawsuit attacking Texas abortion regulation laws. Many places distributed abortion pills, but did so in secret. Many people found out by word of mouth when they wanted an abortion. Other higher-class citizens flew to states with legalized abortions. Although abortion was illegal, many women kept attempting abortion. This goes to show that the government restricting something does not necessarily mean that people will stop doing it. People. You may have heard Jane Roe's name in recent politics. She led the frontier of women's rights and reproductive rights. In her early childhood, she lived in Texas, and she died at the age of 69 in 2017 of congestive heart failure. Before she died, she began to convert to the idea that abortion should be legal, but only to the point where she considered it harmful to the fetus. Essentially, when a woman could feel the movements of the fetus. She converted to Catholicism. She had gone to private boarding school for most of her childhood. Roe had gotten married at only 16 years old and was impregnated 3 times before she was 21. She put 2 of her children up for adoption and attempted to get an illegal abortion during her 3rd pregnancy. It was during her 3rd pregnancy where she sued Henry Wade, saying that a woman's right to abortion was protected by her right to privacy. Henry Wade was the criminal district attorney of Dallas County, Texas, where Jane Roe lived. He argued that a woman's right to privacy was not as important as the unborn child's right to life, and that states have the right to regulate abortion in order to protect the life of the unborn child. He had previous law experience, a ruthless debater when it came to law. He became famous in 1964 when he tried Jack Ruby for the murder of John F. Kennedy. Roe's attorneys, Weddington and Coffey, were both women. Weddington had been one of 5 women in her class, graduating at the top, yet still unable to find a job. After a group of old friends needed legal advice, she joined the abortion rights movement. The group of friends began to wonder if anti-abortion laws could be challenged in federal court, and that's when Weddington reached out to Coffey. Coffey said that she was already looking to challenge Texas laws but needed a plaintiff. Once she found Roe, the race was on. Both attorneys were under 30 when they presented to the Supreme Court. The justices at the time of the lawsuit, which happened in 1970 to 73, were Berger, Douglas, Brennan, Stewart, White, Marshall, Blackmun, Powell, and Rehnquist, with Blackmun delivering the verdict in a 7-2 decision.
The lawsuit. Jane Roe argued to the Supreme Court first on December 13, 1971, and again on October 11, 1972, claiming that a Texas law making abortion almost completely illegal was too vague and violated her right to privacy protected by the First, Fourth, Fifth, Ninth, and 14th Amendments.
Mrs. Weddington, you may proceed whenever you're ready.
Roe, the pregnant woman, had gone to several Dallas physicians seeking an abortion, but had been refused care because of the Texas law. She filed suit on behalf of herself and all of those women who have in the past, at that present time, or in the future, would seek termination of a pregnancy. If the woman is unable to get either a legal abortion or an illegal abortion in our state, she can do a self-abortion, which is certainly, perhaps by far the most dangerous, and that is no crime.
Once a child is born, a woman no longer has a choice, and I think pregnancy may terminate that choice. Recognize the humanness of the embryo or the fetus. And they said, we have an interest in protecting fetal life.
On January 22, 1973, the Supreme Court stated that the right to continue or end an abortion is not the government's decision, as the Texas law violated the 14th Amendment only. The 14th Amendment was ratified on July 9, 1868, and it states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive of any person of life, liberty, or property, without due process of law, nor to deny any person within its jurisdiction the equal protection of the laws. This guarantees some rights to the people in the U.S. are not touched by the state governments, including abortion rights. The vote of the Supreme Court came to a 7-2 decision against the Texas law in other states. The dissent was Justices White and Rehnquist, who argued for fetal personhood, which means that they thought a fetus counted as a person, and thus they thought abortion was murder, which is a common argument of the anti-abortionists even today. They also questioned why privacy is involved in the case, but a majority argued that abortion and your right to privacy are, as Justice Blackmun put it, a fundamental right that is broad enough to encompass a woman's decision whether or not to terminate her pregnancy.
Impact and after Roe v. Wade. Immediately after the lawsuit, women across the country were given access to different forms of abortion. Abortion was available through the mail, the doctors, and other places. Many other reproductive tools became more available as well, like birth control and contraceptives. The amount of orphans born to white women after the case went down by 34 to 37% within the first 5 years after the case. In the years and decades following, the women's rights movement would continue to make abortion more accessible to people of color, people living in poverty, and younger people. Today, less than 0.3% of women getting legal abortions need to be hospitalized. However, the U.S. has a long, hard history of racist healthcare practices that still continue today, including areas with more limited access to abortion, discrimination by some providers, and racial stereotypes. Roe v. Wade was re-challenged in 1992 by Casey, who sued Planned Parenthood of southeastern Pennsylvania, with the Supreme Court overruling Roe's trimester pregnancy and replacing it with a system that was less beneficial for reproductive rights. Roe v. Wade was overturned after Dobbs challenged Jackson Women's Health Organization in 2022. The Supreme Court stated that the U.S. Constitution said nothing about abortion, and abortions had nothing to do with privacy. So therefore, states were allowed to regulate and permit abortion as they please. Though Roe v. Wade was overturned, its legacy lives on today. Women's rights and reproductive rights were challenged then, are being challenged today, and always have been. The ideas of Roe, Weddington, Coffey, and the reproductive rights movements, along with the women's rights movement, continue to live on today. Roe v. Wade explored a new frontier of reproductive rights that many continue to strive towards today. Though it was overturned, its ideas, goals, and accomplishments still live in the hearts of many who continue to fight for women's rights and reproductive rights.